Welcome back for Module 8, and Module 8 is all about AI client disclosure. Let's start with the question clients are starting to ask. Was AI used in preparing my case? It is a question that more clients are asking. It is a question that panel procurement teams are putting in writing. It is a question that Allende and Haringey 2025, and that is this court case right here, was implicitly raised for every firm who fee earners use AI tools in clients' work. So, back to this court case very quickly. If I quickly jump down to page 4, I've mentioned this in previous modules, but in summary, you've got two lawyers that use ChatGPT to put together some case law that was submitted to court verbatim. Unfortunately, the information was fabricated, false citations, as well as docket numbers. This case made it very clear with regards to the fee earners what their requirements are and what standards they need to keep with regards to using AI. Now, for most firms, it is a question that they cannot answer with a documented process or a consistent approach or a ready-made disclosure. And this is what we're going to cover today. Now, the scenario is Halstead Cole is the legal firm that we are using throughout this 10 module. If a client later discovers that AI was used in their matter case through a subject access request, a court disclosure exercise, or a complaint investigation, and the firm has no record of having considered whether to disclose that use, the firm cannot demonstrate that the omission was a deliberate, considerated decision rather than an oversight. Now, the SRA's investigation will focus on whether the COLP had a process for making that decision. So, the absence of the Doc AI Management System disclosure document is an absence of that process. And in this module, we're going to build that disclosure documentation. Okay, so in ISO 42001 Annex A.2 uses the word should and not shall. Now in ISO IEC directives part 2, should is a recommendation rather than a hard requirement. This is a deliberate collaboration, blanket mandatory disclosure of every AI tool used in every client interaction. Would be operationally impractical and contextually inappropriate. The standard recognizes this. What the standard does require is that the firm has a documented process for making the disclosure decision. So, in plain English, Annex A.2 does not prescribe the answer to should you tell the client. It requires that the firm asks the question, consider the question, and record the decision in the matter file. So the disclosure documentation is the instrument that captures that question, that consideration, and that decision. The disclosure templates are the tools for how the answer is communicated, but the procedural discipline is the core compliance obligation. Okay, so let's go down to section 3, which is the disclosure decision framework. Now, the framework below is the operational heart of this disclosure document. It applies to every AI use in every matter. So what we're going to do is yes or no at each step to see what action follows. Okay, so this framework produces either a disclosure template, whether that's A, B, or C, or a recorded non-disclosure decision. Both is defensible in a regulatory review. Okay, so let's take a look. So the first question, was AI used to generate, draft, summarize, or materially inform any substantive content, whether that be advice, correspondence, submissions, or analysis that would deliver to or relied upon by the client? So if the answer is yes, AI was used to materially inform substantive content, the disclosure question must be considered further. So question 2 is, would a reasonable client in this matter expect to be informed that AI was used given the nature of the matter, the fee arrangement, and the client's known sophistication? So let's just say, yes, it would be reasonable that the client would expect some sort of communication to say that you was using AI. Now, a reasonable client would expect to be informed. Disclosure framework proceeds to the template check. So proceed to question 3. So question 3 is, does the client care letter or engagement agreement already include template A, the standard AI disclosure clause? Okay, so here we're going to say no. Template A was not used in the care letter. Issue template B, matter specific disclosure letter. So you need to issue template B now, record in the matter file. So you can see that in this scenario, the client was not made aware, but there is an actual framework. So the client wasn't aware that AI was used in their case. Fine. Would the client expect to be made aware? Yes. Okay, no problem. Submit template B. And we're going to see these templates shortly. Now, if we reset this and we're going to redo the questions, but we're going to do the other answer. So again, was AI used? No, it wasn't. Okay, great. So no AI content was used. Record the no disclosure decision in the matter file. No client disclosure required. Great. Now, if it's yes like before, but this time for question 2, would it be reasonable for the client to be informed? Let's just say in this case, the answer is no. Okay, no problem. Proceed to question 4 to assess whether the use is minor or administrative. If yes, record non-disclosure with reasons. So, question 4. So, is the AI use minor, administrative, or ancillary? And would disclosure create a more confusion than transparency value? For example, spell check, grammar assist, formatting, etc. Now, if the answer is no, the use of professional judgment, when in doubt, disclosure issued template B and record the rationale in the matter file. Now, I do this to show that, again, regardless of your answers, whether it's yes or no, both are defensible in the regulatory reviews. Reason being is there's an actual framework. Okay? And here's why both outcomes are defensible. So the SRA is not disclosure every AI use. It is consider disclosure in every matter and record the decision. A firm that records a considered decision not to disclose minor AI use. So, for example, question 4 and the yes answer, yes path, has not discharged the obligation. A firm that records a decision to disclose question 3 yes path or template B, so issue template B, has discharged it differently. The audit failure is not the disclosure decision itself. It's the absence of the record decision. The matter file AI disclosure record is what makes either outcome defensible because there was a recorded decision. Okay, perfect. All right, so let's look at the 4 ways this process can fail. So the majority of firms do not fail because they actively decide not to disclose AI use. They fail because they don't have a decision framework at all. The 4 non-conformant categories below cover the realistic failure modes for Annex A.2 compliance. Okay, so let's look at the first one. So that's no disclosure procedure documented. The firm has no framework for deciding whether to disclose AI use. Individual fee earners make an ad hoc judgment that are inconsistent across the practice. Neither outcome, disclosure or non-disclosure, is recorded in the matter file. When an SRA investigation or a panel client review asks the question, the firm cannot produce a documented answer for any specific matter. So when it comes to an auditor, the response from the auditor is no documented AI client disclosure procedure exists. Annex A.2 transparency expectations is unaddressed. SRA February 2026 guidance obligations unevidenced. Okay. The next failure is client care letters do not address AI. So the standard agreement letter has not been updated to include an AI disclosure clause. So no matters opened after AI tools were adopted contain no reference to AI use. Even where AI has been used to draft correspondence on that very matter, template A from the disclosure documentation addresses this with a single insertion into the standard care letter. It takes one working session and immediately puts all matters into the correct footing. So when it comes to the auditor's response, their response would be standard client care letter template not updated to address AI use. Annex A.2 prospective disclosure obligation is unaddressed for matters opened after the AI policy was issued. The third failure is no matter file record of disclosure decisions. So even where disclosure has been made informally, verbally, or in passing correspondence, it has not been documented. The firm cannot demonstrate to the SRA, a panel client, or in litigation that it considered and made a deliberate decision in any specific matter. The matter file, AI disclosure record, is the one-page record that closes this. Capturing the AI system's use, the question 1 and question 5 decision tree outcome, the disclosure actions taken, and the fee earner's sign-off. So when it comes to the auditor's response in this failure, their response would be no matter level record of AI disclosure decisions available for any active matter. The SRA's expectation of professional judgment under February 2026 guidance is unevidenced. Then the final failure is panel institutional clients not addressed separately. So panel clients like Pemberton Capital, which is the client from this scenario, have explicit AI governance questionnaires. Treating them the same as individual consumer clients with the same care letter disclosure clause fails to address the individual client's needs for a structured, documented account of the firm's AI guidance framework. Template C is the institutional client AI governance statement, the document that answers Pemberton Capital's question 5 with the specificity a panel client requires. Now, when it comes to the auditors, their report would say no template or framework for responding to panel client AI governance questionnaires. Institutional client disclosure obligations addressed only by generic care letter clause. And that is your 4 failures, common failures. Okay, so let's focus on the fix. How do we fix this? We fix this by coming up with 3 templates. Okay, so the disclosure documentation is not a policy document. Okay, it's a template pack. So it contains 3 ready-to-use disclosure instruments, the decision framework, and the matter file recording mechanism. The 3 templates map to 3 disclosure contexts. That is the prospective, that's template A, matter specific, which is template B, and the institutional, which is template C. All right, so template A, care letter engagement agreement AI clause. So a standard clause for insertion into the firm's client care letter template. It discusses that the firm may use AI tools, describes the governance framework, confirms human oversight applies, and invites the client to raise any concerns. General and prospective covers AI use across the matter rather than any specific instance. Operated for all AI use in the matter unless a specific high-risk use triggers template B additionally. Now for template B, standalone AI disclosure letter. Now, standalone letter for matters where template A was not in the original care letter and AI has been used, where high-risk AI system has been used, or where professional judgment indicates disclosure beyond template A. Specific, identifies the AI system at the category level, the task it performed, and the human oversight that was applied, so the human in the loop, as well as the client's right to ask further questions. So that's all in template B. Then you have template C. So template C is a structured response document for panel questionnaires and institutional client AI governance inquiries. Now, this addresses the firm's AI governance framework, that is the AI management system, the gap register, the ISO 42001 alignment, and the disclosure procedure. Now, this is the document that answers Pemberton's Capital question 5. Okay, so let's look at the actual template. So, template A, the client care letter AI clause. So, this will be inserted into whatever document, and it would basically say, we may use artificial intelligence tools to assist in providing legal services on your matter. Where we do so, such tools may be used to assist with tasks including drafting, research, document review, and summarization. Now, all AI assisted work is reviewed by a qualified member of our team before it's used in your matter, and we remain fully responsible for the quality and accuracy of all work we deliver to you. Notice that's in bold. Okay. Now, we maintain a governance framework for AI use, including documented oversight procedures and data protection controls. We do not use AI tools that process your personal information in ways that are not covered by appropriate data protection agreements, and your confidential information remains subject to our professional duty of confidentiality at all times. Okay. And you obviously give them the option in terms of if you have any questions about our use of AI tools in your matter, or if you would prefer that we do not use AI tools in any specific aspect of your matter, please let us know and we will accommodate your request whenever possible. All right. So this is template A that gets put into any client care letters that is sent out. Okay, template B. So this is matter specific AI disclosure letter. So this is a full letter. So it goes out to the client. The subject is obviously the reference number of the client matter in question, use of AI assistance in your matter. So I am writing to let you know that in the course of working on your matter, we have used an AI tool to assist with, and then you give a description. So for example, reviewing the documents, preparing the first draft of the correspondence, etc. Okay. The AI generated content was reviewed by the fee earner, so the senior solicitor, before it was used, and any errors or inaccuracies were corrected. We are satisfied that the work delivered to you accurately reflects our professional advice and is not solely the product of AI generation. So if again, you got the small disclaimer at the bottom to say if you have any concerns about this, or if you would like us to explain how we use AI tools in more detail, please do not hesitate to contact them. All right, so this is a specific letter itself. Then you have template C. Now this is an actual statement, okay? So what will happen is you'll put in the firm name, Halstead Cole, operates an artificial intelligence management system, so that's the AIMS, aligned with ISO IEC 42001 2020. Our current documented controls cover the AI policy, which is leadership approved, 6 mandatory sections, the AI system register, so every deployed AI system with risk tier and oversight mechanism. Also got a risk register, so that's the 8-factor structured AI risk assessment for each system. We also got the data governance register, so lawful basis, the data processing agreements, overseas transfer, and data minimization. We also got the AI disclosure pack, so that's the 3 templates, decision framework, and matter file records. And then finally, the human oversight procedure. Right, so you will notice that the client disclosure obligations are addressed through a structured decision framework. For any matter in which AI is used to generate substantive content, our COLP signed procedure determines whether and how disclosure is made, and the decision is recorded in the matter file. We welcome the opportunity to provide further details on any specific AI system or its governance control. So those are the 3 templates. Now, this is how Halstead Co. can actually complete their top clients' AI governance questionnaire. So with this module complete, module 8, Every question on Pemberton Capital's 5-questionnaire AI governance questionnaire can be answered with specific documented evidence for the AI management system. The summary below is the firm's responsive capabilities. Every question is mapped to a controlled document signed by leadership and updated on the documented review cadence. So let's look at these answers to Pemberton Capital's AI governance questionnaire now, which Halstead Cole 30 days, a 30-day deadline to complete it. So question 1, who owns AI risk in your firm? The answer to that is the responsible, accountable, consulted, informed AI management system document, which we covered in module 3. So AI risk owner and AI governance lead formally designated by management resolution. The CLLP, in case of this scenario, is PRIA, holds regulatory interface, documented names, authorities, and accountabilities, not a single point of failure. Okay, so question 2. What AI tools does your firm use in client matters? Okay, so that is answered by the AI management system documentation for each AI system. We covered that in module 4. And that is every AI system registered with a risk tier, intended use, oversight mechanism, vendor, and data categories. So Microsoft 365 Copilot split by deployment context, i.e. Word, Outlook, Excel, and so on. So that's per system level documentation requirements. Then you have question 3. So how do you identify and manage AI specific risks? Okay, perfect. Halstead Cole now have a risk assessment documentation. So 8-factor structured AI risk assessment using the 5x5 likelihood times impact matrix. 2 high rated risks documented with target remediation dates and ongoing quarterly reviews. Now, question 4. How do you monitor AI systems after deployment? And how do you protect client data in them? Perfect. There's a documentation for that as well, which we covered in module 7. So, lawful basis per system and data category, vendor, data processing agreement confirmed, overseas transfer mechanism recorded, data minimization rules per system, special category data blocked until DPIA is in place, UK GDPR plus ISO 42001 clause 8.3 is satisfied simultaneously. And that's all done by the Reg AI management system data documentation. Then finally, question 5, which we've answered in this module. How do you communicate AI use to clients? And that is the AI management system disclosure document. So 5-question disclosure decision framework, 3 templates. That's template A, that's the care letter clause, template B, the matter specific letter, and template C, the institutional panel client governance statement. Matter file recorded for every disclosure decision. And those are the actual 5 questions in the AI governance questionnaire from Pemberton Capital answered, all by having the correct frameworks and documentation in place. So Halstead Cole has gone from we don't have an AI policy, which was module 2, to a documented leadership approved AI management system that answers every question on their £620,000 a year panel client governance questionnaire with specific evidenced instruments. The framework is defensible under both ISO 42001 audit and the SRA regulatory scrutiny, and it is reproducible in any mid-sized UK law firm without disproportionate investment. The remaining operational controls, G8, human oversight procedure, is the natural next module in any continuation program. Okay, so that's module 8. We've covered the client disclosure, and again, so staying within the same pattern as all the previous modules, I've provided you with a quick check questionnaire with a series of questions, only 3 in this actual module, as well as a completion checklist as you work through understanding the scenario, understanding Annex A.2, the failure modes, and the readiness to respond with regards to the 5 questions to Pemberton. Now, I've also provided you with a template, of course. So an AI client disclosure pack. If we scroll down, it's got some instructions in terms of how to use the pack itself. But as you can see here, section 1, you've got the AI client disclosure decision framework. So the different questions in terms of what AI use was generated, who would be responsible in the client matters. So we covered this in terms of those questions in, if I just go back here, so we covered this in these questions here. So was AI generated, drafted, summarized, used to summarize, etc. And you chose yes or no. So that is that section here and their answers. Okay. Then we start moving on to the actual templates in section 2. So you got this client care letter, AI disclosure form, and here I've got the statement in terms of use of AI tools. We may use AI tools to assist use in providing legal services in your matter, etc. All right, so that's the actual statement. Again, this is just a template to give you an idea of what the type of information that goes in these sections. Please feel free to edit the document and update it accordingly. Then you've got the template B. I'm not sure why it's coming out like that, but nevertheless, now you've got template B, which is the matter specific AI disclosure letter. And here is again just a template. And then I'm writing to let you know, of course, we're working on your matter. We've used AI tools. You give a description in terms of how it was used, and also state the senior solicitor or whoever reviewed is confirming that they reviewed the output from the AI and is satisfied with the information that is up to the standard of accuracy that the firm expects. Then you've got section 4. So this is template C, the institutional client and panel AI governance, statement. And this is going to be the law firm's letterhead, the date, its information, and then its actual governance statement. So the AI governance framework, the AI systems in active use, the risk assessment, the human oversight, the data protection, the client disclosure, the regulatory alignment. Okay. And again, this is just template information that I've put here so that, again, you get the idea of what goes in these sections. And then you've got section 5, the matter AI disclosure record. So this is 1 record per client matter. So you're putting in the reference number, the matter name or the client name, the solicitor that is compiling the information, when the AI tool was used, and then you're following the relevant questions in terms of, was AI used for substantive client-facing content? Would it be reasonable to expect the client to know about it, and so forth? Okay, so each client matter has this AI disclosure record. And then I've got section 6, which is the implementation checklist. So when to actually issue certain documentation based on what questions and so forth. All right. And then I've just provided a little compliance summary. So in terms of the Annex A.2 requirement, and then the actual documentation that addresses it. Okay, so that is, scroll down, that is module 8. And I will see you in the next video for module 9. And in module 9, we're going to cover the human in the loop. So the human oversight. See you on the next one.